13-213 State versus Ben Dacus, possession of methamphetamine with purpose to deliver, assault, criminal mischief. 13-227 methamphetamine, controlled substances, paraphernalia.
There's no action to take on either case.
Stay in contact with your lawyers, sir. 13-139 State versus Michael Everett, possession of Schedule 3 controlled substance, possession of paraphernalia, public intoxication. 13-139.
We'll just leave that scheduled for trial.
Okay. Stay in contact with your lawyers. 13-71 State versus Kevin Metheny, hot check.
He's paid the restitution in full today, Judge.
Oh, I see. You're pleading guilty to a misdemeanor hot check charge?
Yes, sir.
You're giving up your right to have a trial and you're also your right to appeal. Do you understand that?
Yes, sir.
Are you entering this plea freely and voluntarily?
Yes, sir.
And because you're guilty?
Yes, sir.
This time, sir, I'm going to judge you guilty, place you on 1 year unsupervised probation. Will he need to pay cost?
No, Judge.
Okay. You're to pay court cost of $200, $100 fine, $200 in public defender fees, a $20 booking fee. You've already paid restitution.
Yes, sir.
Okay. And pay the sum due at the rate of $100 per month beginning within 60 days, or I guess 30 days. Let's make that 30. And make your payments to the Sheriff's Department.
Okay.
There you go. 13-37 State versus Mitchell Smith, methamphetamine, driving on a suspended license, no proof of insurance, nor a seatbelt.
Yeah, I think we're set for a jury trial next month.
Okay.
Just leave that as scheduled.
12-287 State versus Larry Bell, possession with intent to deliver methamphetamine, possession of morphine, K2.
Judge, we're scheduled for trial on the 9th. We're ready for trial.
Okay. Stay in contact with your lawyers, sir. State versus Austin Morris, burglary, theft of property, criminal mischief, 12-281.
Judge, there's no action to take today except for trial on the 9th, and we're ready for trial.
Very well. Ready to go.
Thank you.
13-81 State versus Kerry Riddell, delivery of marijuana near certain facilities, delivery of cocaine near certain facilities, delivery of ecstasy near certain facilities, marijuana near certain facilities.
Your Honor, we have an agreement in this case.
Yes.
However, there's one more step my client needs to take before the plea will be officially offered.
Okay.
We can do that before the 5th of December if you would have her appear then for plea.
You want her to reappear on the 5th, you say?
Yes, Your Honor.
Okay, reappear on December 5th, 10 o'clock. State versus Shelley Emmers, also known as Shelley Lindsay, theft of property, 13-31.
Judge, there's no action to take in either of Shelley's cases today.
Okay.
Just leave them as scheduled.
She has 13-207 also.
Correct.
Very well, I'll
Thank you,
reflect
Judge.
that on the document. 11-90, State versus David Hutchinson, non-support. On a revocation.
You know, I visited with Mr. Nucio this morning. He said Mr. Hutchinson is doing very well on probation at this time, but he's still not cleared all his hurdles with child support enforcement. He's paid approximately $1,600 on support in the last 6 weeks. We'd like to kick this back to the first of the year, waive the 60-day requirement once again.
Continued on defense motion till January 30th, 10 o'clock.
Thanks, Judge.
Thank you.
That's 1340 and 1341. Mr. Wheeler, I'm looking at two police statements here. Have you gone over these documents?
Yes, sir.
And it looks like you've signed them. Is that
Yes, sir.
correct?
Yes, sir.
Do you feel you understand what is set out in your police statements?
I believe so.
Okay. Do you understand the charges against you and the possible range of penalties if you're convicted?
Yes, sir.
In case number 2013-41, are you pleading guilty to terroristic threatening and theft of property, both misdemeanors?
Yes, sir.
In case number 2013-40, are you pleading guilty to breaking and entering and theft of property? The breaking and entering be a felony and the theft a misdemeanor.
Yes, sir.
By entering these pleas, you're giving up your right to have a jury trial, and you also give up your right to an appeal. Do you understand that?
Yes, sir.
Are you entering the pleas freely and voluntarily?
Yes, sir.
Other than the recommendations in your plea statements, has anyone promised you anything in order to get you to change your plea?
No, sir.
Have you been threatened or coerced in any manner in order to get you to change your plea?
No, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
In case number 13-41, did you threaten your neighbor in some manner?
Judge,
What
on January
happened?
the 18th of 2003, this gentleman entered his neighbor's yard for the purpose of stealing a plastic playhouse and a leaf blower. When she caught him in the act, he threatened to shoot her.
Did you do something? What happened?
She caught me trying to get, stuff from her, but that never happened.
Okay. In, let's see, 13-40, what happened in this case?
Judge, on the following day, January the 19th, 2013, this gentleman broke into the residence of Jeff Janaway and stole a gold bracelet.
Okay.
Valued at $300, and he did damage to approximately $200 to the property.
Did you do that?
Yes, sir.
Okay. At this time, sir, in case 2013-40, I'll judge you guilty on the breaking or entering charge. You'll be sentenced to 6 years probation. On the theft of property charge, a misdemeanor, you'll receive 120 days in the county jail. In 2013-41, on the theft of property, you receive a sentence of 60 days in the county jail. Do you need a conviction on threatening?
Judge, I need a conviction on threatening because I want this gentleman during the period of his probation not to have any contact with the victim.
Okay. Is you willing to plead no contest?
We'll change our plea to no contest to that charge in exchange for the plea offer that was made in this case.
You would still be convicted, you just wouldn't have to admit the facts.
All right.
So Mr. Chisholm stated facts that you said weren't correct, but are you not contesting those facts? You're not admitting, but you're not contesting. You need to talk to your lawyer about that.
I'll explain it to you. You're not saying that you did it. You're just saying that you're not going to contest it because of the
Yeah.
offer that was made.
Yeah, I agree with it.
Okay.
Judge, part and parcel of that, and I don't see it on the police statement, that this gentleman will have no contact with that victim.
Very well.
We saw that coming, Judge.
Okay. In 2013-41, you're also convicted of terroristic threatening, be placed and serve 60 days in the county jail on both charges. Everything runs concurrent. In 13-41, you'll pay $200 in cost, a $250 fine, $200 to the public defender, a $20 booking fee. In 2013-40, let's see, that's one where you have 6 years probation, 120 days, $200 in cost, a $1,000 fine, $200 to public defender, DNA fee of $250, $550 in restitution, a $20 booking fee. Pay the sums you owe at the rate of $100 per month, beginning within 60 days after your release.
Yes, sir.
You make your payments to Sheriff's Department.
Your Honor, will
Yes.
it be permissible to add that no contact to
Yep,
the...
there will be no
I think we can
contact.
add that to the special conditions of his probation, that this gentleman have no contact with his neighbor. We can add that as a special condition. Is that agreeable?
Very well. Anything further on that case?
Thank you.